Hello everyone, this is Tom Fox and I'd like to welcome you to episode 269 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by the Red Flag Group. The Red Flag Group is a business advisory, information services, and technological firm that helps clients manage risk across 4 key risk areas. They include sales and sales channels, suppliers, customers, and human capital. You can find out more information on the Red Flag Group at www.redflaggroup.com. That's www.redflaggroup.com. Today, I'm very pleased and privileged to have back my good friend and colleague, Mike Volkov. We take a deep dive into the Johnson Controls FCPA enforcement action. We both thought this was a bit of a head scratcher because of the conduct of the company and their position as a recidivist. Nevertheless, I thought it was important from the perspective of the pilot program and the lessons learned for the compliance practitioner. Mike talks about some of the facts and what he thought the pilot program and indeed the Yates memo might mean for enforcement as set out in the Johnson Controls case. This episode is a little bit longer than normal, coming in at just over 30 minutes, but I think you'll find that if you listen through, you'll get a lot more information about the Johnson Controls enforcement action than you typically will get. And I hope that you enjoyed listening to this episode of the FCPA Compliance and Ethics Report. Hello, everyone. This is Tom Fox, and I am back with my good friend and colleague, Mike Volkov. And we are here today to talk about the Johnson Controls FCPA enforcement action. As most of you know who have read my blog post, I stole from Mike when I said this is a real head scratcher. And we both had some questions about this. So, Mike, first of all, tell us where you're talking to us from today.
Well, Tom, I'm in Sicily, Marsala, Sicily, where I spend a lot of time, as you know, each year. And it's beautiful here. It's been enjoying the food, the wine, and family, so having a great time here. But nonetheless, I work from here, believe it or not.
Truly international practice.
But international practice, that's true. Except my workday sometimes starts at 2 o'clock in the afternoon, but that leaves plenty of time for a good lunch, each day. And I'll tell you what, the best seafood in the world is here. The freshest fish, the most sweet-tasting, delicious fish in the world that you can have is here. So having a great time, and if anybody ever is interested in Sicily and touring here or doing something, please feel free to reach out to me. My wife would be happy to help in making suggestions and places to go and things like that. So you always have a home here in Sicily, Tom. You know that for you and your wife.
So anyway, I guess talking from his Sicily office today. But Mike, this case was a head scratcher for lots of different reasons. The first of which was really what we both believe was the seriousness of the underlying allegations. And I'm just going to kind of walk through some of the facts, really as you reported, that the JCI subsidiary was called China Marine, and they acquired China Marine through acquisition of York International. And at the time of the acquisition, China Marine had been found guilty of FCPA violations, and York International actually had paid a $22 million fine to the DOJ and SEC to resolve the FCPA offenses in China and other countries between 2001 and 2006. And subsequently, when Johnson Controls took over, they fired the staff of China Marine and brought in a new set of folks to run the operation. Yet this new set of folks also started up yet another bribery scheme. And they did this by a very sophisticated means of overbilling from clients, and they would pass these costs back up to the corporate office. They would get rebates and send them to distributors who would pay the bribes out. Apparently everyone in the senior management of China Marine was in on the deal, starting with the managing director, the head of finance, head of sales, and it really is a complete, total, and utter, I hate to even say compliance failure, because that would imply there was something in place. But it was a bribery scheme which involved the top level of the company. The subsidiary was run out of a Danish or Denmark subsidiary, China Marine was, who allegedly or were tasked with oversight. And I think we both agree that the oversight was just abysmal. So maybe with that, you might turn to how did Johnson Controls get a declination out of this?
Well, that to me, Tom, and that's a great summary of the facts, is the real question here. I do not understand how DOJ gave a declination in this case, because to me there are two other, I think, important facts. One is that, and I was surprised to read this, and I'm sure you, in following, the FCPA, that this was a case where there was an independent compliance monitor assigned for 3 years prior, as a result of the York International Enforcement matter. And one of the recommendations supposedly made by the compliance monitor at the end of the 3rd year was that they should integrate more the China operations into the Denmark operations so that there is more supervision, or, bring functions, more of the day-to-day functions, let them be run out of the Denmark office. And I think, and that was viewed as a significant risk according to the facts that we have here from the FCC enforcement action. And the fact is that they ignored that recommendation. Now, I don't know if there was a justification for it, but clearly that recommendation was ignored. And to me, it almost is directly I would call it the proximate cause of why these violations were able to occur. The second point that I would make about this that's interesting is that even though they impose strict financial controls, in terms of delegations of authority and the authorizations that people had at China Marine for low amounts. So, for example, like a $3,500 payment could be authorized at the local level in China, but let's say everything above that had to be approved by the Denmark subsidiary. Well, they were able to structure all of these payments that funneled close to $5 million in bribes over a several-year time period by keeping the transactions below the authorization level that would require Denmark subsidiary to review the transactions. So these things, so not only did this involve a lot of people, but it involved a great number of transactions that occurred. And to me, those two things by themselves, and the fact that we have a recidivist in a sense, I cannot understand DOJ's declination in that context. I fear, and I hope I'm not speaking out of turn here, but I hope that the DOJ didn't do this declination as a way to sort of promote, again, the FCPA pilot program. In other words, here's another declination. We now have 3, and we're trying to show everybody, come in and tell us whatever you know, disclose your problems, and we'll guarantee you that you get one of these declinations. But I'm very troubled by these facts, and I'm not saying I'm encouraging the government to go after people, but it's hard to explain this when you're advising clients in the context of a past record of enforcement as to when it makes sense to do a voluntary disclosure or not. So this is somewhat difficult for me to explain, and I would love to know what DOJ's real thinking on this was. Now, there could be something, Tom, that we have no real feel for, which is the nature and extent of the remediation that Johnson Controls put in place. It sounds like the cooperation was tremendous. And who knows, maybe there's something that was really, really special here that we just don't know about.
Well, Mike, in a minute, I want to ask you about the process by which parties really negotiate over the statement of facts in either a Department of Justice resolution, DPA, NPA, or Securities and Exchange Commission resolution, cease and desist order, or other document. But before we do, let me just go through the actions, remedial actions that Johnson Controls took. They terminated all of the culpable employees. The managing director of China Marine had voluntarily quit before or immediately during the pendency of the internal investigation. They suspended the culpable third parties who've been involved in the bribery scheme. They incorporated the China Marine offices into the existing corporate structure, doing away with that separate office. They enhanced integrity testing and auditing, including random audits at the business units in question, and they engaged in random testing of the transaction. So their remediation, I think, was extensive as well. But one of the things you raised, Mike, was we don't know all of the facts, and that's certainly true. But I thought it might be interesting if you would explain the process by which a company negotiates with either the SEC or DOJ on a statement of facts. And certainly, and I assume that would occur in the antitrust world or any other time that you reach a resolution with the government.
Yeah, I think the fact is when you agree to a statement of facts, this is a statement of facts that's going to be used, for example, in related civil litigation. These are basically admissions by the company. And although there's protections that this can't be used directly against you or whatever, or you have other protections, for example, in the antitrust world as to how much your damages can be if you cooperate in a cartel case. The fact is that you want to be careful, and there's a lot of negotiation over the specific facts. For example, if I were to resolve a case on a books and records violation with the SEC, my approach as a lawyer would be to sort of, try to pitch the facts and agree to as little of the facts that I can, but enough to satisfy the SEC. And that's why, for example, the SEC's order in this case, and I think there's some confusion among some of the FCPA, bar as to whether or not these are ever a full statement of the facts. They're not. The SEC in particular, there's a lot of negotiation over the facts, and we see a really range of difference in terms of the specifics that are included. Some don't have a lot of specifics, and that reflects the negotiation. Take the Las Vegas Sands case. There was a great amount of detail in that case, and then you take one of the sort of China cases that happened with the SEC more recently, and those are sort of more general in terms of their facts. So we don't really know all of the facts. Now, I will say this, though. DOJ, I do feel like they provide a little bit more of a comprehensive statement of the facts. For example, in Volkov and things like that, those are big cases, and they put out a lot of the facts. So we really, we don't have DOJ's perspective, but I don't think it's fair to say that we can judge what the SEC did here completely on the facts. Okay, they're just questions that I am raising. I'm not saying it's wrong. I call it a head scratcher because I would need more information. And I'm sure there's a different perspective when you're the enforcement attorney or one of the defense counsel handling the case. But, look, the remediation here, as you pointed out, was terrific. I get that. I guess what is troubling to me is that this is a company where there were problems to begin with, and then the problems, it didn't seem like there was much attention to making sure that the company avoided, a recurring violation. If anything, it seems like the place was out of control. I don't even get the sense that there were, any serious audits done. There appeared to be some, additional FCPA training as referenced in the facts, but there were some audits that only revealed missing paperwork. Well, in this situation, if you did a financial audit, like a real comprehensive one of the China subsidiary, I would think you would find real red flags when you were doing it. So that, to me, it sort of just indicates that there were problems throughout this period in terms of how this subsidiary was run. And I think it'll be interesting if we ever get somebody to speak about this, DOJ to be a little bit more transparent about this case. I think, and it just goes to show you that like a $14 million settlement, you sort of look at it and you say, oh, I kind of know what the facts are going to look like, and then you read it, and I was like, I couldn't believe it. I thought this was one of the more serious cases.
So one of the things that struck me, Mike, was that I certainly saw evidence that would lead one to at least posit that a criminal charge or criminal action could be brought. And I saw that in the context of the books and records, both in internal controls and the financial statements, because someone had to certify those financial statements. And generally, you have to certify at the subsidiary, the European headquarters, and those have to be recertified at the corporate headquarters. And on internal controls, even if there were not the specific invalidation of the internal controls, I think you could certainly make a claim or a plausible argument that there was conscious avoidance by the Danish or Denmark subsidiary in their oversight of the internal controls, and perhaps even the corporate office in America. So I guess I saw the possibility of a criminal case. I think you maybe saw it a little bit stronger. But if we take a step back and say, yes, this was bad conduct, but the Yates memo is really specifically designed to answer that question. And the Yates memo sets out 4 components for a company to receive a credit. Not the Yates memo, I'm sorry, the pilot program. And those are self-disclosure, cooperation during the investigation, extensive remediation, and a disgorgement. So if the 4 requirements of the pilot program were met, then the next step is, how did we get to the declination? And I guess maybe that's the linkage that you and I are not seeing or can't quite understand while we're scratching our heads. Hello, everyone. This is Tom Fox again. We're going to take a short break for some technical issues. And in this break, I would like to ask you to go over and check out my new podcast on leadership. It's business leadership, also applicable to the compliance professional. Hello. It's called 12 O'Clock High. I think you'll enjoy it. And I think we have got our technical glitches handled, so back to the podcast.
And Tom, you just went through the 4 elements required for meeting the pilot project requirements, and they clearly did. JCI, Johnson Controls, clearly, I think there are enough facts there to see how they did meet that requirements all the way down to the disgorgement. So that makes them eligible for at least a 50% reduction, right? Or a 50% reduction in the amount of penalties, but it is still open to the possibility of a declination. And I think in this case here, we're not sure about how that jump was made. I really agree with you wholeheartedly in terms of the certifications that were occurring here under SOX, and the fact that the records here and the books and records were so off and so out of control from this subsidiary that there had to have been people who turned a blind eye, in the sense. And holding the company criminally liable, to me, would be a lot different than holding the a number of individuals. And my point was that we've seen the department sort of, I wouldn't say stretch the law, but they have, because they're in the driver's seat, they've used the threat of a criminal prosecution, to get some type of result related to that. Here, they could have done the same, in my view, but again, we have a situation where they declined to do so. I mean, it's not the strongest and clearest criminal case. Because we don't know the facts of what the parent companies and even what the Denmark subsidiary individuals were doing with regard to oversight. And you have to get, I think, enough to the U.S. Operation in terms of their oversight or knowledge, whether they have knowledge or reason to believe. But I think conscious avoidance or, deliberate indifference would probably get them over the hump in the ability to sort of look at this. But I have a feeling that this case was going on for a few years, before the pilot project came out. The Yates memorandum, before the Yates memorandum was really sort of hit. And now I think we're looking at a situation where it might be that, because they're sort of in the gap there, that they were able to escape just under the wire in terms of the Yates memo and even taking a more aggressive approach towards the company. So, I mean, look, I think for clients and companies, to me, there's a lot of good suggestions here in terms of, even if you have in place financial controls, remember that they're non-material transactions that occur all the time. We always used to talk about petty cash cases, but companies are getting rid of that lately. There's reminders as to how you handle your oversight of your third parties and monitor your third parties. And there's just, to me, a great reminder here that you have to dig into your financial paperwork, your authorizations, but also your invoices. You were talking about how they inflated invoices and funded this, and they inflated payments to vendors and to other third parties. So I think there are a lot of sort of compliance reminders about how things can go out of control. And what a surprise this occurred in China. I mean, we've seen these facts going on so many times now. But there are important reminders in there, I think, in general, in terms of the enforcement and compliance lessons learned.
Mike, I certainly agree with that. And the other thing that we touched on was that Johnson Controls cooperated with the Department of Justice quite thoroughly as well. And let me just kind of go over some of the highlights that the DOJ pointed out, which were real-time updates of interviews, interview summaries, all requested documents, updates of facts as they appeared. Yates binders were presented to the department, including hot documents, interview summaries, chronologies, and emails, and they were really separated out where the important ones were put up front so that the department would see those first, and those were articulated to the department. And then there was a preservation of evidence component. And typically, I think every lawyer in the United States would say that's the first thing you do. But there was a problem in China where employees of China Marine actually tried to destroy evidence and were caught doing so. And the company took extraordinary steps to preserve evidence so that it could be presented to the Department of Justice. So the facts facts leading to the factors that Johnson Controls was cited for, both in the thoroughness of their investigation, cooperation during the investigation, and extensive remediation, are things that every compliance officer should be studying and learning and internalizing. And if you do find yourself in one of these situations, you've got a pretty clear roadmap of the conduct the department expects. I would also throw in a shout out to FCPA Inc. here, because this, Mike, really emphasizes to me you have got to bring in significantly experienced FCPA counsel to walk you through each one of these, because it's not that the stakes have raised in terms of the fine and penalty. That's been going on for a long time, but the stakes have been raised to the extent you as a company can receive a declination if you take these extraordinary steps. And by having competent, experienced, and really seasoned FCPA counsel advising you, I think it will give you a huge lead in moving forward and trying to get the type of result that Johnson Controls got.
Yeah, I want to sort of concur with you on whoever represented Johnson Controls here, did a great job. And in terms of going the extra mile, and they must have been able to persuade them, quite well. So they must have had credibility. And there is a point to FCPA Inc., people who know what they're doing. because they have credibility with the prosecutors and the trial attorneys over at the SEC as well. So that's definitely something to look out for if you get involved in one of these situations. What I think the other point that you raised, that for compliance people in general, if you're caught in a situation where you're starting an investigation and you think it's a small FCPA issue, and who knows what it might turn into, and you don't have outside counsel brought in right away, these are all good points that you're making in terms of laying the groundwork so that if it does grow into something more significant and outside counsel has to be brought in, that at least the preliminary work is going to be will fold into whatever work has to be done to meet all these requirements. So that's a very good point, I think.
So I guess, Mike, it really we really didn't resolve anything here. We were both scratching our head with kind of the same questions we had when we started. I guess for my final thought, I will disagree with you because I think this is an important case because the declination was granted. And I think it's significant that the department took the steps, or excuse me, granted the declination. What I continually ask of the department, and I've asked for from the head of the FCPA unit every time I met with them, is to please make public the facts of the declination, because when you have a declination, that means that some very experienced FCPA counsel thought there was enough facts that they should be self-disclosed, and a corporate board made the decision to self-disclose. So somebody thought there was arguably a case there, and if we had those facts, I think you and I could probably be better advised, be more well situated to advise our clients on the kinds of things that you can make a comeback from. And if Johnson Controls stands for one proposition, it may be that if you take the program factors from the pilot program and apply them to your enforcement action, you can get as good a result as you could hope for.
Yeah, look, I don't disagree with you strongly at all about that. I think that you've done a lot of work in sorts of pushing the department to be more transparent, and with your conversations, and ultimately leading to the guidance that came out in 2012. And I hope that they the more that they provide to us, the better. In terms of helping clients to deal with these difficult issues, because a lot of times the scales may get weighed in a way that's going to say no disclosure, whereas if we know more and have more certainty, there may be situations where we would recommend disclosure. So I think it's in the department's interest to be a little bit more open here, and they're trying. I mean, look, they're putting out the declination letters now, which lists the factors and at least provide some, listing of what went into the consideration here under the pilot program. My concern with the pilot program has been that I don't know that the 50% incentive is enough of a reduction off of the bottom of the sentencing guideline range. Frankly, declinations and things like this provide more incentives. So it may be that in practice we're going to see more declinations than we expected, Tom. That's what may happen here. And then we may be in a position of advising clients, you know what, if we can get the benefits of the pilot program, it may be worth it.
I think you're on to something, Mike. In my blog today, I took a look at the 3 declinations that have been granted since the initiation of the pilot program. There have been 4 cases. On the 4th case, an NPA was granted. That NPA was granted because the DOJ felt the company held back and didn't fully cooperate during the investigation. So that was the reason they didn't get the declination, I think. But maybe you're on to something there, that in practice the DOJ is moving towards that declination without the formal structure or formally agreeing to it, which I don't think they'd ever do anyway, but they certainly didn't in the pilot program. So maybe that's something that we need to consider, and maybe we need another podcast on what's happened since the pilot program.
Well, I think, in a few months we're going to have more of a track record. I also think that we're going to see more individual prosecutions over the next 6 months, and I think that's going to be a direct result of the Yates Memorandum. So, I have always said that these policy pronouncements are important because they do filter down to the individual prosecutor and the supervisor. And I'm still convinced that both of these programs are going to have they've already changed the landscape. And I think they're going to continue to do that, and we're going to see more evidence of the change. And you're right, 3 out of 4 is not bad, particularly because that fourth case, you're right, the department was the ones who discovered that the company had held back, or some individuals at the company had held back on some information, so they didn't get the full credit. Well, that just goes to show you that when you do an internal investigation, it's even more important to make sure you get every last detail out, because you don't want to get blindsided by a department follow-up investigation.
Well, Mike, I'm surprised because you actually have me more heartened than I was when we started our podcast. So maybe we could.
Well, I'm always an optimist. I'm always an optimist. You know that, Tom. But you're an optimist too.
That you are. So, Mike, thanks a lot in calling in from your Sicily office, and perhaps we can have next time. I should just come to your Sicily office, and we should record live.
Absolutely.
All right. Well, thanks a lot.
Always welcome here.
We'll continue the conversation.
Thanks, Tom.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. As I mentioned, I have a new podcast on business leadership. It's called 12 O'Clock High, and you can check it out on iTunes under the name 12 O'Clock High. You can also find it on my website at 12o'clockhighleadership.com. Also, I have a new white paper on innovation in compliance that's available on this website. So you can download a copy of the white paper at no charge simply by give us your email address. So check that out on the website that you're listening to this podcast on. And if you're listening to this podcast on iTunes, I hope you'll rate this podcast. It would greatly help us. This is Tom Fox. I'd like to thank you very much for listening and look forward to continuing the conversation.